Peace, everybody. We're going to jump straight into it. Go to riseofthemoors.org. There's a bunch of information. This is zoomed in. That's why it looks like that. And I zoom in so that when I'm reading things like this, you all can see it. All right, so that's why it's so zoomed in. Go to riseofthemoors.org. We have a bunch of new books. This book right here is free. This is a free book right here. We have Moorish Tactical by Grand Sheikh Mafiel. We have Thoughts and Writings of Lucha El. We have a children's book on the left, The Little Moorish Seafarers by Moreno Bay. And we have this book here called The Blue Bible. These books right here are all written by other Moors, collaborating with other Moors to try to push their products as well. So is this right here, this book on adverse possession. But that's not what this video is about. This video is about due process. So click on due process on riseofthemoors.org. This is free information. And if you are unfamiliar with due process or you want to know a little bit about court procedure for free, this information is available. I see your comment, Jello. That's why I'm trying to hold in my lap. This information is available. I had a consultation with a Moor today. And again, my consultations are not legal advice. This is just, I've been studying law for about 7 years. And over the 7 years, by helping Moors just comprehend their rights and knowing what the law is, Moors have been able to get cases dismissed by just having discussions about, jurisprudence and the science of law and things like that. Moors have gotten cases dismissed. So I don't give out legal advice. You are, as an individual, responsible for making your own decisions. So these are some of the cases that have been dismissed. And for those of you who've been following Rise of Moors, you already know what it is. But anyway, I had a consultation with Moore earlier about what was discussed in my book that has been out since 2018, at least. And it has to deal with the title of the video. So this is in the book, Are You Confused About Law? Right now, you can use the coupon bestseller on checkout and get $15 off. $15 off. All right, so this is talked about in the book, Are You Confused About Law? Feel free to read that on your own. Again, this information, I've been making this information available to Moors, but obviously, the more people are waking up by the grace of Allah, the more people are learning and the more guidance that they may need. So this information on due process is available. What I find common, and this isn't just me finding it common, anyone that does their research on any type of law or reads any type of case law will often hear about this, the Fourth Amendment, which is the right to due process, right? How no one shall be deprived of life or liberty without due process of law. It's specifically specified in the Fifth Amendment. But the Fourth Amendment deals with searches and seizures, which is also dealing with due process of law. So briefly, due process of law is the application by state, I read that all wrong. Due process of law is application by state of all legal rules and principles pertaining to the case, so all legal rights that are owed to the person are respected, right? Now, many people know what due process of law is basically the correct process by which you are taken through the courts, right? One of the main issues that are discussed, or one of the main arguments in court regarding due process of law is what's called a motion to suppress. So if you don't know what that is, write it down. And again, I'm not going to read all of this for you on here. I typed it for you. and put the necessary links from other sources for you for free already. So I'm not going to read it to you. So I'm just going to be going over general things. If you don't know, look it up on your own. Anyway, a motion to suppress is basically saying that what the state is presenting as evidence against me was taken without a warrant, was taken without due process of law, was taken without probable cause, and was taken without reasonable suspicion. That's all that's saying. So, as an example, just this case right here, as you see on the screen, right? We'll go to it because the information is available regarding this. So go to riseofthemoors.org. As you can see, click on books and other literature. Click on this is clickable, or you can just scroll down and go to here, right? But you just most of the things are interactive. Anyway, click on it, and you see offense description: dangerous weapon, carrying a dangerous weapon, possession of a large capacity firearm, possession of large capacity firearm. Obviously, that's double jeopardy. Ammunition without FID card, or possession of ammunition without FID card. False ID information, arrestee furnished to law enforcement. Right. So these charges were dismissed. A lot of the times, when it comes to things like this and a motion to suppress, cases will be dismissed, and the court will say, prosecutor is unable to sustain his burden of proof at trial, therefore this matter is dismissed. So when you file a motion to suppress, in it you're articulating that because the police violated your right, whatever they found, and this applies to anything, cannabis, even things that are not protected by the Constitution, such as cocaine. If the police found whatever it is that they found without probable cause or reasonable suspicion, then they cannot use it against you. It's called fruit of a poisonous tree. And if you look up any case law regarding a motion to suppress, you will often see that phraseology being used: fruit of a poisonous tree. All it means is that the evidence that the police, detective, prosecutor, whatever, obtained was in violation of your right to due process. So, as an example, if you are in your mode of conveyance, because I know more is like specific words. If you're in your car, the word car means carriage. So if you're on the road and you're being carried on the road, and you have an arm on you, and let's say you're speeding, we already know traffic infractions are not crimes, right? The police see you speeding, boom, they pull you over. All they can do is give you a speeding ticket, because that's the only infraction that you are alleged to have violated. If they then ask you to exit your vehicle and then proceed to search that vehicle, they have already violated your right to due process. One, if they pulled you over for speeding, then you are detained. Two, once you are detained, they have to read you your Miranda rights. And three, in order to search your vehicle, they need probable cause and or reasonable suspicion. So if you just pull over for speeding, that doesn't meet that threshold of requirement. So if the police in court during your motion to suppress hearing, you would have the right to cross-examine them. You would ask them what was their probable cause to ask you to exit your vehicle, because now they're physically detaining you. They're making a seizure of your person. Right? Let's look up the Fourth Amendment. Right. Congress.gov. Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So they would need probable cause to ask you to leave your vehicle. They would need probable cause to search your vehicle, right? So you're secure in your physical body and your effects, meaning your car, and your documents, meaning your IDs and birth certificate and social security number, et cetera, against unreasonable searches and seizures. So the seizure has to be reasonable. So the cop would have to clearly articulate under oath in court during your motion to suppress hearing, while you're asking him What was your reason for asking me to exit the vehicle? Well, you were speeding. That's not sufficient to give rise to a search under the Fourth Amendment. Likewise, we'll go here. riseofthemoors.org. This information, I made it free for everybody. I mean, it was already free, but I compiled it so that way you don't have to go to 18 million places like I did to find the information. All right, we'll see here. All right. That under the Fourth Amendment, the mere possession of a handgun was not sufficient to give rise to a reasonable suspicion that the defendant was illegally carrying that gun. Carrying a handgun or a gun, period, is not necessarily a crime, and thus there was no probable cause to search a vehicle. So just because, even if they see it in plain sight doctrine, that does not give them a sufficient rise to reasonable suspicion of anything. Now, if the cops were called and during the police 911 call, the individual said, hey, there's an individual with a gun pointing it at people and yelling and being aggressive, now there's reasonable suspicion. But if there's a call that just says, hey, this person has a gun, there's no reasonable suspicion. Right? So during your motion to suppress, you're challenging the nature of how they even found whatever it is they found. And this doesn't just apply to arms. This applies to anything. Right? And the police would have to clearly articulate what they're there for. Right? So a lot of our people, when they're facing these charges, have a motion to suppress argument or Fourth Amendment argument, which is the same thing, where they can argue that the police obtained this alleged evidence against me under unlawful circumstances, which is called, again, fruit of a poisonous tree. And it's that simple. Obviously, there's going to be more particulars on a case-by-case basis because everyone's situation is different. But those are some general concepts for you to comprehend what your rights are. And of course, most lawyers aren't going to tell you what your rights are. They're just going to do whatever it is that their job is. But remember, they're officers of the court, and their first obligation is to the court. We already know that a lot of these prosecutors and attorneys make deals with each other. We already know that a lot of these judges were former prosecutors, so they're not even on your side anyway. We already know a lot of these judges are practicing law from the bench. They have, if you look up their name, they have a whole law firm where they litigate cases, but they're also a judge, which is against the United States law. But anyway, know what your Fourth Amendment rights are because they're very important to you. They're very important in general. And again, like I said, when you look up Fourth Amendment violations, you'll see that there is, just because these people are cops, or just because these people are detectives, or just because these people are prosecutors, or just because these people are judges, does not mean that they're infallible. It does not mean that they do not make mistakes. It does not mean that they're omnipotent and all-knowing. That's not what these things mean. These are human beings that make mistakes. As an example, look at this image right here, where it says case dismissed. They put the wrong date. They put 1/4/2022. So these people make mistakes. Right, and you can use that mistakes. Obviously, if it's just like a clerical mistake, then you might not be able to use that for your defense. But if it's a mistake of law, such as a Fourth Amendment violation, then you can absolutely use that in your defense. And remember, let me see right here. Let me see. 1 second. Remember that, right? Identifying the moment of seizure is a critical question for purposes of deciding to suppress. Right? So you have to figure out when you were actually seized by the police. Now, this is important because, again, not only do you have the right to a Miranda warning, right? Which when they stop you, that is, if they stop you on the side of the road, that is a stop. They have detained you, which means they have to give you a Miranda warning, but they don't. Right? But you have what is called a consensual encounter, a temporary detention, which that's a traffic stop, and an arrest. The Fourth Amendment applies to the latter two. Thus, a police officer must have a reasonable suspicion to conduct a temporary detention or probable cause to conclude an arrest. Now, if you're just stopped for speeding, right, then they're alleging reasonable suspicion. They think that you're in violation of the law because you're going fast. So then they just give you a ticket, right? But if they ask you to leave your vehicle and to search your vehicle, they need more than reasonable suspicion. That's just what it is. Also, when you're facing gun charges, under the new, it's not really new. Moors are still posting on Instagram as if this is new. It's not new. Under the standards established by the United States Supreme Court, uh, often known as the Bruin decision, it forces judges to do a historical analysis inquiry into the constitutionality of the state's licensing statute, but that's only if you challenge it. So if you're being charged with possession of a firearm without a license, you have the right under this new decision to challenge the statute that you're being charged with. Now, what's interesting, not, not what's interesting, if you do your history on the Second Amendment, you'll see that for almost 20 years, most judicial thinking about the Second Amendment was wrong, and that the Second Amendment was always an individual right, and the fact that hundreds, if not thousands, of people have went to jail under the premise that it wasn't an individual right is just absurd. And as they say, a grave miscarriage of justice, because innocent men and women went to prison because of just exercising the Second Amendment right. So, with this United States Supreme Court case, it said, in keeping with Heller, we hold that the Second Amendment's plain text covers an individual's conduct. The Constitution presumptively protects that conduct. To justify its regulation, the government may not simply posit that the regulation promotes an important interest. Rather, the government must demonstrate that the regulation is consistent with this nation's historical tradition of firearms regulation. Now, I only have a few minutes left, so I'm going to wrap it up pretty soon. Now, I read, Lucha L sent me the decision that the judge made in his case. And I assumed, and I'm pretty sure I'm correctly on to assume this, that they're going to use the same rationale in the Massachusetts case. Now, the reason why I say that is not a mere allegation. It's because the federal judge in Lucha's case in New York used case law that was not brought up to him by the prosecutor in that case. He used case law that was brought up before Judge Deakin in Massachusetts by Van Epps to justify the federal legislation on the licensing of arms. Now, what's interesting, not interesting, it's ridiculous, is that he used, or the prosecutor used, laws from when the colonies were under Great Britain to justify the laws that they're using today. And one of which was in response to the Boston Tea Party, where the colonists threw all of the tea that belonged to Britain into the ocean. And during what is known as the Boston Massacre, where a British redcoat was murdered by the colonists, the British responded by saying, we need to license the colonists' right to bear arms. That is what helped cause the revolution against Britain. So the federal courts are using the rationale as to why the Europeans revolted against Great Britain to justify the same regulations that they're using against the people today, which means that these people are redcoats. Now, again, the United States Supreme Court said they have to use, where is it at? This nation's historical tradition of firearms regulations, not Great Britain's. Right? Let me see if I can find that real fast. I'm going to hold on one second while this Streamlabs decides to work. I'm going to not show this for a second so I can go to my email and see if I can find it. There we go. just so you can see that these people are using British colonial laws to justify what they're doing today, which is absurd. This video is going to end soon, so this is where I'm going to leave it. Let me see if I can find it real fast, because it's crazy. It's crazy. That's not it. That's not it. I think it was before that. Let me see. Nope, that's not it. Here it is. Let me see if I can find it. um, just let me just show you this so you can see for yourself. This is the case. All right, let me scroll down. Right, so this is them saying that it's consistent with this country's history and tradition of firearms regulations. Right, let's see if we can find it. All right, record of colonial and early state era laws. The movement of firearms between colonies. For instance, apparently as part of an effort to prevent firearms from falling into the hands of Indian tribes. Right, so they're already basing it off of something that's unconstitutional. Right, Connecticut banned. It doesn't say the year of it though. Connecticut banned the sale of firearms by its residents outside the colony, but that was to prevent Indian tribes from having it, which is already unconstitutional, right? Let me see. India. So again, they criminalize giving other people arms, which is dealing with the state of servitude, right? And we're talking about 1763. This is before the United States became a country, which means it was still subject to Great Britain, right? 1639, 1645, 1656. These are the very when you do your research, these are the very laws as to why the colonists revolted against Great Britain. But they're using it to justify their actions today, right? Colonial authority, that means Great Britain. Right? Uh, they made it unlawful to export from the United States any cannon, musket, pistol, bayonet, swords, cutlasses, musket balls, lead, bombs, grenades, gunpowder, etc., 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 etc. Why? Don't just look up the law. Look up why they did it. Right? And again, I already wrote a response to this for the Massachusetts issue. But if you want to learn more, if you're facing these bullcrap charges, which they are, I do have a consultation service where we can talk about this philosophy of law right here. And again, the proof is in the pudding. I'll just show you. The proof's in the pudding right here. This is available. Trial Court of Massachusetts. These charges. Dismissed. Case dismissed. So if you do have an attorney, ask them about your Fourth Amendment right. Ask them about your motion to suppress. And ask them about challenging the constitutionality of the statutes that you're even being charged with under Bruin. Peace.